Yes, you can start.
Yes. Good evening and a warm welcome to everyone. I'm the moderator for today's session. My name is Pushyami and I'm studying law at Sastra University, Tanjavur. Today is the 26th of November, Samvidhan Divas, also known as National Law Day. On this day, 70 years ago, the Constituent Assembly of India had adopted our Indian Constitution, which came into effect on 26th January 1950. On this special occasion, I would like to remind a quote of Dr. Abdul Kalam, which shall stay relevant for generations. The quality of constitution lies in the desire of general population to shield it. On this occasion, we have a very distinguished guest with us for today's session. It's an honor for me to introduce today's speaker, respected Mr. Vikramjit Banerjee, present Additional Solicitor General of India and Senior Advocate of Supreme Court of India. For lawyers in Supreme Court and Guwahati High Court, Mr. Banerjee needs no introduction. Mr. Vikramjit Banerjee is a senior advocate and is currently serving as Additional Solicitor General of India. He previously served as Advocate General of Nagaland. Mr. Banerjee is an NLSIU Bangalore 1997 graduate. He has also served as a senior advocate in Guwahati High Court, Assam. Mr. Banerjee is the youngest in the batch of three additional solicitors general who have been appointed at Supreme Court. He is also the first NLU graduate to make it to the post of ASG. It is a proud moment for all of us to have you here speaking in this session today. We welcome you, sir.
Thank you. Thank you.
About Think India, who have organized this session today. Think India is an initiative to bring together the best talent of this country and to infuse them with a nation first attitude. It is an active forum of researchers, professionals, and students where they debate on national issues, raise their concern, and offer innovative solutions to problems. It is a platform for leaders of tomorrow. So far, Think India has provided students with many opportunities which has helped them grow academically. Think India also provides various internships to students like Vidhi internship under esteemed lawyers for the law students, Sansadhya internship under members of parliament, International Law Commission internship under Dr. Anirudh Rajput, member of United Nations International Law Commission. For more details about the internships, you can find on Think India's website, which will be provided in the comment section. The Constitutional Law Forum is one of the initiatives of Think India, and it comments the essentialness of our Indian Constitution and the qualities that our Constitution maintains. The forum targets creating enthusiasm among the youthful personalities towards the established law throughout different considerations and conversations that general public attempts to undertake. Our topic for today's session is freedom of expression and censorship. An important note to everyone. I request all the participants to mute their mic to avoid any disturbances. And if you have any questions, you are requested to type it in a chat box so that I will ask Sir the questions and we can discuss them in question and answer session. Without taking any more of your time, I would like to pass on to respected Mr. Vikramjit Banerjee. Sir, over to you.
Thank you very much. And it's wonderful to see how Think India has grown to where it has. I remember having discussions when Think India was still a figment in people's minds, that people wanted to have an association of very intelligent intellectual students like Think India. And today, the role and shape which Think India has come into is a vindication of the dreams of its founders. Thank you again for inviting me to speak in Think India. And I will address that topic, and I'll try to. Today is Constitutional Day, so it's a day of great rejoicing. It's a day in which the Constitution was ratified by everybody, by the Constituent Assembly, though it came into effect in 1950 on 26th of January. But it is a great day in the history of any country, the formation of the Constitution, and for effectively accepting it in a country as diverse, as large, as populous as India. It's a great thing, and today is in fact a day of great celebration and a day which is a milestone in the life of any country. That being said, now coming to the topic of discussion which has been given to me to speak to you, freedom of speech and freedom of speech and expression and sort of constitutionalism as it, what are the contours of freedom of speech and expression and where do we stand on it? Freedom of speech and expression, there are old Indian sayings, and I'll come to that later, which talk about freedom of speech and expression. But freedom of speech as we know it today, as we see it strictly today, in the formation, in the formulae of individual rights, traces its lineage back to possibly the Roman Empire, and most prominently during the struggle between the king and the parliament in England. We all know and that we are part of the common law heritage. So as being part of the common law heritage, we have also relied on the history of common law as has developed in the wider world, including that of England. To that extent, freedom of speech and expression as we know it today comes to us from England, from the developments of England. And especially the conception of freedom of speech starts arising in England during the time when, very famously, the Parliament and the King start fighting with each other, literally. So in 1644, I think the first tract is written advocating freedom of speech and expression by the famous poet, English poet whose name you may have heard of, John Milton, where he sort of advocated he published a book, a tract called Aeropagitica, where I think he advocated the fact that no freedom is complete without freedom of speech and expression. It was in many ways a small broadside against the king, who was trying to, in his own way, limit freedom of speech through expression, through specific charters which he was giving out. Now, in 1689, this came to be codified in the Bill of Rights, and which then became part of common law. I think 1689 was also after this huge amount of struggle between the Parliament and the King, and in Britain or in England, which is called the Glorious Revolution, is after the establishment of a Commonwealth, that is a republic, which was established in England by Cromwell. The Commonwealth did not lasted for 10, 15 years, and then it was replaced by the King again, James II, Charles II. Charles II was followed by his son, James, who again the Parliament had trouble with. And the Parliament then throughout basically ensured that James I left the shores of England completely. And when it brought in a new king, William of Orange, it ensured that the agreement between Parliament and the William of Orange incorporated a Bill of Rights. That is effectively, in modern constitutional law, the first sort of sign of Bill of Rights that we have seen, especially in common law thinking, in which, in this Bill of Rights, freedom of speech and expression was very specifically incorporated. There's a large history of that, but that is a different story. In 1789, literally 100 years later, this was incorporated during the French Revolution in the rights of man, very famously, when 100 years later, or 150 years later, the French did the same thing, which the English had done, basically cut off the head of the king. In 1791, the First Amendment of the US happened, where the right of freedom of expression was incorporated. That, as we all know, historically, the French Revolution and the American Revolution had a lot of back and forth. There were actors in both, which participated in both these events, and in many ways they fed off each other. The American Revolution, in some ways, was in many ways was an offshoot of the English common law system, and therefore was expressed a lot of these ideas which were part of the English common law and codified it and made it into the American Constitution as we know it. The American Constitution, right at the beginning, as I'm sure that we all know, did not incorporate a Bill of Rights, but subsequently, after that was the First Amendment, they brought in the Bill of Rights, including the right to freedom of speech and expression. That being said, that is the history of freedom of speech and expression, and I'll come to India to how we got it a little later. But I think, what is the counterbalance of freedom of speech and expression? Freedom of speech means you have a right to say, you have the right to speak your mind. As Milton said, freedom, you cannot have any right unless you have the right to freedom of speech and expression. Unless you can express yourself, all rights are futile. You should be able to say whatever you want without fear of retribution from the state. That's part of freedom of speech and expression. Greatly debated, but that's how it has always been. Now, what is the counterbalance of freedom of speech and expression? The counterbalance of freedom of speech, and the first sort of institution that we see, which could be sort of talked about as a counterbalance to freedom of speech and expression, is the post of censors, from which word censorship comes. Censors existed in the Roman Republic. There were two of them. There were two magistrates under the Roman Constitution of their own right, very powerful position, who basically looked after and ensured that public morality was kept, so that whatever in your speeches, in your actions, they were to ensure to the census, which we know is counting of people, and they were also to ensure that people's morality was kept intact, and to that end, they had very strong powers, and their decisions were not even appealable in the Roman Republic. They could only be overturned after the election of a new censor. This is, to be fair, this is not something which is unusual. Anyone who, again, knows Indian administrative legal history knows that during the time of Ashoka, there was similar positions called the Dhamma Mahamattas, who enforced the Dhamma across the spectrum, across the society, and basically also ensured that people followed the road of the Dhamma, exactly like the censors did. And to that extent, they were also responsible in ensuring that freedom of speech and expression and dissenting views in societies would be curbed to an extent. Anyone who studied the role of Dhamma Mahamatta would be aware that it was a very important post under the Mauryan times, which is not very unusual. In India, freedom of speech and expression, there is a long history of freedom of speech and expression. A large amount of the struggle which we had during the time of independence was predicated on the entire conception of freedom of speech and expression, especially the tendency of the British Raj to try those who spoke against the state, against the British Raj in any way. They were tried. Some of them were sent to prison. The stories of Mahatma Gandhi, the story of Lokmanya Tilak, the stories of Aurobindo Ghosh, and their struggles with the British Raj are legendary. The famous statement of Lokmanya Tilak, freedom is my birthright and I shall have it. It comes from that context, the context of some of the most Aurobindo Ghosh, or Rishi Aurobindo, as we know, his press being shut down, of Bande Mataram being prosecuted, arose from the mentality of the British state to clamp down on dissent, which it sort of said that it arose from largely what it termed as indigenous press or local press, who wrote in local languages and who expressed their dissent against the policies of the Raj. Broadly, so when we achieved independence, because of this enormous struggle and history of enormous struggle that we had with the entire conception of freedom of speech and expression, one of the first things which we wanted to incorporate in our constitution was the concept of freedom of speech and expression. Freedom of speech and expression, and I'll come to that later as to what are the two models, but I'll address that later. But freedom of speech and expression by the courts have been handled, and I broadly see it in three phases. I won't go into detail because there were other questions which I will address, but freedom of speech and expression was handled basically under three large, broad trends. The first was the Ramesh Thapar judgments, which I think was in the 1950s, where the courts and the trend of the courts was to ensure that your freedom of speech and expression was protected and at all costs. So the press was to be protected, and the right to say whatever one wanted to say was to be protected. So that was the largish trend at that point of time. This arose largely because of we had just come out of independence. There was this entire struggle which we had gone through to protect our right to say whatever we wanted to, and so therefore that was protected. The second part of it, and was in the 1970s, and during the time of emergency, we all know there was a huge pushback by the state. The courts were also a little soft on the state, and so judgments like K. Abbas happened, whereby the court sort of said that public morality has to be considered, has to be given importance against whatever one says. So you didn't have an infinite right to say whatever one wanted to. In the 2000s, there are two famous judgments in Supreme Court which are quite often quoted. One was in relation to films. One was in relation to the Padmavat judgment, and the other was about the Bengali film Bhuter Bhovishyat, which is also extremely well quoted, in which the court basically said that your right to freedom of speech and expression has to be protected, and you should not be curtailed, and you should have the right basically to say whatever one wanted to. Now, that historically being said, and that's extremely important that one contextualizes that, the broader question arises is, what is the model of freedom of speech and expression that we have inherited? There are two basic models, and I'll say why in India we have a very unique model. The first model is the American model. The American model comes from a libertarian ethos. A libertarian ethos is, infinite liberty. So the restriction of a freedom of speech and expression, as there's a U.S. Supreme Court judgment called Chaplinsky, which basically said, you cannot, the restriction to freedom of speech and expression, I'll tell you, is lewd and obscene, something which promotes rebellion, something which is profane or basically makes horrible things, to say sacrilege, horrible things to say about gods. And the last is fighting words. Is that something which causes an immediate reaction, which can cause violence? So these were the sort of 4 or 5 exceptions under which the state could pass law or regulate the freedom of speech and expression. Now, if you go to the Indian model, and this is an interesting thing which comes again from some of the discussions which happened at the time of the Constituent Assembly, and some of the unique reasons of India why we've had this very nuanced idea about freedom of speech and expression is because when we incorporated it and then we had a subsequent amendment, I think there is this wonderful book which is going around, which is being circulated all over as to what was the debate leading up to the First Amendment, where these changes as to the right to say whatever one wants to was changed further. But broadly, we accepted that we are not going to have an absolutist interpretation of freedom of speech and expression like the Americans had. So we sort of restricted it on decency, morality, contempt, defamation, and public order, sovereignty, integrity of the state, and so on and so forth, friendly relations with other states, security of the state, public order. So we decided right from the beginning that we are not going to have an absolute right of freedom of speech and expression. Now, the question which arises is, why did we choose to do that? The answer to that is also extremely simple, is because we realize that we live in a diverse society. And for the want of a better word, when I try to explain, and people have different sensitivities, people are very diverse, people have sensitivities, people get offended. Violence can result of this, people being offended. We have seen numerous examples of that in day-to-day happenings in India, even very recently, where people are driven to violence by small statements made by small people. There are numerous examples. I don't want to take them by name, but we know even during Padmavat what happened. We know during numerous instances, people get into violence, and so there was an attempt to sort of ensure that no one had an absolute right to freedom of speech and expression. I think the crux of it is, how important does one see freedom of speech and expression, and how does one see freedom of speech and expression in a society? In an American context, everybody should have the right to say whatever one wanted to, while we sort of, as Indians, contribute to the philosophy which, very famously, what is narrated a number of times in the Mahabharata, which says that wounds inflicted by swords can heal, or wounds inflicted by arrows and instruments can heal, but wounds inflicted by words will never heal. So we have always believed that it is important, and if you look at the Tirukural as to how to speak in public, how to hold forth in an assembly, we have always stressed on the fact that you should speak something which is nice, which is sweet, which is nice to the ear, which is acceptable to people to hear. You can say the most bitter truths by conveying it sweetly. It doesn't have to be aggressive. It doesn't have to be violent. So that has been the way we have always culturally, civilizationally addressed this issue of freedom of speech and expression. We've always accepted that freedom of speech and expression has to be largely limited. Now, why is freedom of speech and expression such a challenging issue today? I think the basic reason why freedom of speech and expression is such a challenging issue today is because of the internet. There are two parts of the internet. Two parts of freedom of speech and expression, and one is out and out state regulation of speech. We all saw the Kerala bill, where the state still wants to regulate speech. And it's not that it only happens in Kerala, it happens everywhere. Kerala was a legislation which was brought forward, but I think all over India, there has been a tendency to cut at the root of freedom of speech and expression, because people don't want unpalatable truths to be put to them. I think the Shreya Singhal judgment, the Supreme Court came down on that and said, no, there is importance of freedom of speech and expression, and struck down provisions of the IT Act 56A on the ground that it curtailed the freedom of speech and expression. That's one aspect of it. The other is the other thing where the state is increasingly being faced with a challenge is the content of programs which are being broadcasted through directly into your homes. Netflix being one, which there are others which do not conform to the standard public morality which people may adhere to in this country, while on the other hand, the reach of Netflix is much wider and much more deeper than actually even cinema halls, because cinema halls, you will have to buy a ticket to go to a cinema hall. With Netflix, you can actually watch it on your cell phone. So it can reach to deepest parts of India, deepest parts of society, and the content of a large number of these shows are in many ways contrary to the public morality, which is a restriction on your fundamental rights. Now, the entire question is, how does the state do that? There are various ways the state can do that, but in many ways, whenever the state steps in to regulate the internet space, it is questioned. It is very strongly questioned by different groups. There are libertarian groups which push back. There are liberal groups which push back. There are pro-internet groups which push back. But increasingly, and this is something which we should also flag, that this is not only an India issue. There has been prosecutions which are now being launched even in the United States of America, which has a very wide scope of freedom of speech and expression on Netflix, and especially on questions of child pornography. So these issues are there. These issues face us. There is a very interesting story by this science fiction author, Arthur C. Clarke. Arthur C. Clarke basically envisaged this sort of a world which will happen, where he said that you will have content going into people's houses without the intervention of the state, and then how will you control it? There is no straight answer. There is no straight answer as to how to do that, but these are things which we also have to take into account and try to have a regulatory framework. The third is, I have told you about the problematic nature of the state's attempt to cut down on freedom of speech and expression. But let us flip it around and let us look at it from the other side. Let us look at it from the role of the social media as to how it has created tensions in society. We know the role of Twitter, we know the role of Facebook. We also know, of various different social media which can be used to ferment divisions in society, which can exacerbate divisions, which can create riots, which can create huge issues in society. Some say for good, some say for bad, but definitely it can. We know during these riots which happened both in India as well as in the United States of America, social media was used extensively for the purposes of these things. We know that that social media like Twitter and Facebook were used to bring down regimes through international actors in different countries, whether it be through the color revolutions or whether it be through the Arab Spring. Inconvenient, so you can use social media to political effect. Added to this is the misuse of social media through something like Cambridge Analytica, which is a machine which has algorithms which can actually, I went through it at that point of time, can predict actually how you can think. They can make you think in a certain way. They can regulate your actions a certain way using the amount of data which they have gathered from your Facebook or social media handles. They know what sort of message to send to you. They know what sort of message to make you feel in a certain way. They can do it for making you buy things whenever, and this we've seen a number of times. All of us who now have Google phones know that if you discuss something, 2 seconds later you will see it as part of your Google search, suggested searches. If you want to buy something, 2 days later you get a suggestion of that very product on your Facebook page. So it's used commercially, but Cambridge Analytica shows that it can be used politically, and there is no way and no reason to see that it cannot be used politically. Social media can also be used as there is a large amount of material. There's a large number of voices, especially in conservative or for that matter, nationalist voices in America, in India, who say that the social media and especially Twitter and Facebook have algorithms, have methods whereby it regulates and it ensures that voices which they don't consider to be politically correct, which is basically left liberal sympathies, get traction. So that if you have a tweet, they have various methods which to ensure that it doesn't get out to very many people. If you have a Facebook post, there are methods to ensure that it doesn't get out to very many people. So basically, there's a censorship which is being built into the media itself. Now, this leads us to the second question, as in, what do you do with this? How do you regulate this issue as to censorship, but not by the state? Censorship of voices can be for commercial reasons, can be for political reasons. Because of, again, as I explained, because of the political stand of Twitter, of the social media company which runs those accounts, and for commercial reasons, like the reason why Twitter continuously, there is this line of thinking why Twitter continuously advocates Chinese positions of the Chinese government, because it benefits economically, and so therefore, it doesn't promote any goods, doesn't promote any commercial speech also which goes against that or interests of the Chinese government. So how do you handle this sort of censorship of free speech and expression by social media? One can obviously make an argument that it's social media, it's a company, so it's private, they can regulate it themselves, and you can't have anything to do with it because it's not run by the state. But in the age of the internet, when one's freedom of speech and expression is completely integrated to the internet, to social media, this is not an argument which can be countenanced. The answer frequently thrown by a lot of people is, okay, if you don't agree, if you don't accept Twitter, don't accept Facebook, form your own Twitter, form your own Facebook. But I think, considering the monopolistic nature of both Twitter and Facebook in the social media, I don't think this is a possible alternative. But there are issues which need to be looked at, and there are challenges which need to be faced. There are issues which are extremely important that we face it right now. But I think the most important thing is, are there clear answers? How do we regulate it? I don't think there are clear answers. I personally don't think there are clear answers. It's a process which we are going through, and I will think that internet, most of our institutions of governance, as we know today, whether it be the state, whether it be individual rights, whether it be democracy as we know it, are products of the industrial age, of the products of an industrial age which took into account newspapers, which took into account industrial production, which took into account the governance in models of state as we have seen it. So it basically is 300 years old and has its own history. I think with the internet, with societies being created onto the net, with societies which in many ways are globalized and yet needing regulation, we have not been able to yet come up with a formula of how we are going to regulate these questions of freedom of speech and expression. We have to develop it. We have to develop it. It's a slow process because in many ways, the state, as we know it today, is a product of the industrial age, while internet is the product of the next generation of post, not even post-industrial, of the internet age. So being a product of the internet age, what its demands are completely different. Its solutions which you have to suggest is of the internet age, and for the state to do that becomes a little bit of a disjunctive question. But these are questions which we all have to face. As I am fond of saying that constitution is like dharma. Constitution is the dharma of the state, is basically which holds the state together. And constitution depends on three things. It depends on, like dharma depends on three things. It depends on sthan, kal, and patra. Patra is the individual, is the person, patro, the person who is directly affected. While individual rights, freedom of speech and expression arises from being the patro. The kal, the times require creative interpretation of constitutionalism, which is the dharma of our times, to come up with a holistic solution to freedom of speech and expression. A solution which incorporates commercial entities, which incorporates social media, which also incorporates the problems of the state. No perfect solution exists, but this is the most important challenge of our times. Thank you.
Stupendous talk. You have discussed many interesting topics, right from the history, and have also discussed about the issues and the challenges right now are facing. We are very thankful for that. And I request all the participants, if there are any questions, you can please type it in a chat box. Yes. I hope there aren't any. So I would like to proceed with formal vote of thanks. I should thank Sir for imparting great knowledge. I, on behalf of Constitutional Law Forum and Think India, extend my heartiest gratitude towards today's esteemed guest and speaker, Sri Vikramjit Banerjee Sir, who spared time from his busiest schedule to grace the occasion. Today, we had an opportunity to hear your thoughts, which have enlightened our minds and have shown us a new path. I express my gratitude to you for gracing the occasion and sharing your valuable opinions today. We hope to see you in more such sessions. I also extend my heartfelt thanks to Think India for their contributions in making this event happen successfully. This event would not have been possible without the constant support and opportunities Think India gives to the students. I would also like to thank all the people who have joined us today in this talk. We hope to see you in some more of such sessions in the future.
There are few questions. People are actually
Yes,
okay. Just go through this
yes.
chat box.
So there is one question which was directed.
Yeah.
It is from Shivansh. Sir, can OTT platforms be allowed to hurt religions sentiment of a particular religion in the name of freedom of speech and expression? That is the question, sir.
This is the crux of what I was saying, and I realized this is a tough question, a question which needs to be addressed. And I said that this is not a question only in India. In America, where you supposedly have completely unlimited freedom of speech and expression, this issue about our Netflix and child pornography has come up. We are facing it not only on religious issues, we are facing a number of issues, especially including that of public morality, violation of statements made against religion, and so on and so forth. These are questions which we will have to address. On one side is the nature of the internet, the nature of the internet, which is globalized, which is sort of globalized value systems, and on the other hand is the very intrinsic nature of our society. I personally think there should be a balance, and increasingly it is a felt need across the world, not only in India. India, I won't express what the policy of the government is on that, but this is a felt need over the world, and I think it's extremely relevant. It's extremely relevant that we ensure that a balance is struck. How do you strike that balance? Whether you go for internal regulation, an internal regulatory mechanism within the companies, or whether you have a state-imposed one, that is something which the state has to discuss and come up with. But I think that there should be clear guidelines in relation to the content of such OTP, over the top, of such content like Netflix.
Yes, sir. So there's another question. Sir, how do you see the law of criminal court of contempt when taken along with freedom of speech and expression?
Again, this, the answer to that goes directly back to the entire question of what sort of society is we come from. We come from a different kind of society than what is in Britain, or for that matter, America. Why do we? The other question is more than criminal contempt. I think the other question is, why do we still have criminal defamation in our books? The reasoning why we have criminal defamation in our books has always been the fact that we are diverse, and very diverse, very sensitive country, and any statement made by us can result in violence. So the test usually in criminal defamation is also that, something which you've said, something which can result in violence. So on that, and on the question of criminal contempt specifically, I think it's extremely important because of the nature of society, which we have. So to ensure that the majesty of the law is protected, it is important that we have criminal contempt to enforce the decisions of the court. Because as we know, for the want of a better word, the institutions of governance in India can be implemented in two ways. One is through society, and the other is through the use of the state, force of the state. Use of society is done in the case of panchayat. They have mechanisms to do it, but how do you otherwise implement the decisions of the judiciary? Criminal contempt is one of them, and I think it's still very, very relevant.
Sir, there is another question. Sir, don't you think self-regulation means no regulation at all?
I don't deny that. That's a question. That's a very relevant question. So you are asking, in many ways, for the state to step in and to regulate it, and therefore to come up with a regulatory mechanism of the internet. Some would argue that it is a slippery slope. The shoe is on one foot today, it can be on the other foot tomorrow. What is to stop the laws that you put in place? What is to stop some other government or some other people? Let's not even talk government, but some other people with a completely different mentality, then going after content which they do not agree to. How do you handle that? Because the law is not something which varies from incident to incident, but law is in many ways quite a permanent thing to do. So it can lead to a slippery slope on one side, but on the other, you definitely have the question as to whether self-regulation means no regulation. And because uh, as our experience with television and shows that effectively self-regulation has meant, in effect, no regulation.
Yes. The next question is freedom of expression adequate protection to press and journalistic media or separate strong law needed?
A separate law as to yeah, I don't think that you have a right and you test it. You test it. There are a large number of laws through which you can restrict freedom of speech and expression, and the court tests it on each ground. But I think there's a separate law needed to protect the press? Um, I don't think so. I think we've worked well. We've had a free press. We've had press which takes on the government, and we've had press which is very, very critical of the government, or whichever government, whatever they come, whichever color. So it's worked very well. That's worked very well without having a specific law to that effect, and I think that's okay. That's no problem. Enough laws which regulate it, and so one more law I don't think will in any way solve the issue.
Yes. Uh, I think there are no more questions, sir. So
Thank you.
I would like to thank you once again for giving us your time and for clearing us the questions with patience. Thank you so much, sir.
Thank you.
Thank you.